It takes about 4 inches. That's how far your window drops before the officer leans in and smiles. Evening. How you doing tonight? Polite, human, almost warm. And in the next 90 seconds, a quiet little machine starts running. Not traffic, not law, just a script. Rehearsed, tested, fine-tuned, designed to move you, bite by bite, from a driver into a suspect. Here's the part no one tells you. The script isn't aimed at criminals. It's aimed at you, at the honest driver. The one with the registration up to date. The one with nothing in the trunk but a stroller. Because you're the easiest target on the road. You want to be nice. You want to be helpful. And the officer's entire job in those 90 seconds is to convert that goodness into evidence. Stick around, because I'm going to walk you through exactly how the script unfolds, the question-by-question psychology behind it, and the 6 lines that break it cold. Everyone is plain English. Everyone is backed by real Supreme Court case law. And the third one is the single most common mistake good people make. It hands the officer a key the Constitution says he could never take by force. Then I'll show you how to keep it. Quick note before we go. This is legal education and commentary, not legal advice for your specific situation. I'm not your lawyer. Your circumstances may change things. A defendant in cuffs has options I can't protect in a video. Use this as a map, not a shield. I'm Jake. On this channel, we break down what to say and what not to say. When the lights come on behind you, using the actual statutes and the actual rulings that put the steering wheel back in your hands. If that's the corner you want in your corner, hit that button before we go further. It actually does help the next driver find this when they need it. Now, the part everyone skips. Before we look at any single move, you have to see the architecture. There are only a handful of things an officer is allowed to do. The entire script is built around pulling you off the legal map and onto his. He's allowed to build probable cause out of your own words, out of suspicious movements from your own hands, out of plain view clues from your own glove box, or the magic key, your permission. The whole script is engineered to manufacture one of those 4 things. He is not making conversation. He is constructing a case. You just happen to be the building material. So the first rule of every stop, and the only rule you actually need to remember, is this. Comply with your hands. Decline with your mouth. Win in court, never on the roadside. Your body obeys every lawful order. That's non-negotiable. Reaching, arguing, refusing to roll the window further, refusing to step out, each one creates a new problem you didn't have going in. Your mouth, on the other hand, gives nothing extra. Polite, warm, firm, short. That's the entire engine of the strategy. Now let's walk the script, the opener, the handshake. It almost always starts with one of 3 lines. How are you doing tonight? Beautiful car. Is it new? You folks headed home. Read them again. There's no question in any of them. Those aren't questions. Those are invitations to talk. Why does the script lead with small talk? Because a relaxed person fills silence. A relaxed person explains. A relaxed person volunteers. The officer isn't collecting your travel plans because he's interested. He's collecting them so he can compare your answer to your passengers, to the time of day, to the direction you were driving. The official phrase for that, written into a report later, is inconsistent statements. It's a brick. He only needs a few to build a wall of reasonable suspicion. An inconsistency is the easiest brick in the world to manufacture from a friendly person with a kind face. The line that breaks this one is brutally simple. When he opens, you smile back. You mean it. Then you say, "Doing okay, officer? How can I help you tonight?" 3 pieces, 3 moves, acknowledgement, redirection, silence. You have not been rude. You have not escalated. You have put the conversation back where the law puts the burden. On his uniform, not yours. The trap. Do you know why I pulled you over? This is the most common question in American traffic enforcement, and it is textbook confession bait. Listen to what he's actually doing. He's asking you to write the opening sentence of his report. The minute you say, "Yeah, I might have been speeding a little," or "I know I missed that turn signal back there," you have given him an admission. It comes out of your mouth. It is recorded on his body mic. And the 5th Amendment exists precisely so the government cannot make you do that to yourself. The case he is operating under, whether he knows it or not, is Burkham v. McCarty, 468 U.S. 420, 1984. The Supreme Court ruled that the ordinary roadside stop is not custodial interrogation. You don't get a Miranda warning on the side of the road, which means every throwaway confession you don't even register saying, every, "Yeah, I was probably doing 50 in a 35, is fully usable against you in court. He's licensed to keep asking until you slip. So you don't slip. When he asks if you know why he pulled you over, you say calmly, eye contact, even tone, "No, officer, why did you pull me over?" You genuinely don't know. There are a dozen things that might have brought him behind you. You haven't confessed. You haven't guessed. You have placed the burden exactly where the law puts it. On his side of the windshield, not yours. Memorize that line. Say it every single time. The fishing trip. Where are you coming from? Now the second wave begins. If you let the opener get you talking, the travel questions come harder. Where are you coming from? Where are you headed? What's in the cooler? Whose house were you at? How long were you there? Why were you in that neighborhood? Each one sounds reasonable. None of them are required. Here is what the law actually demands of you during a traffic stop. You must provide your driver's license, your vehicle registration, and proof of insurance if asked. Those are the documents. That is the entire list. State statutes all over the country have echoed this for decades. You are not required to narrate your life. You're not required to discuss where you've been, why you were there, who you were with, or where you're going next. The Supreme Court made this plain in Berkmer. Detention on the roadside does not transform you into someone who has to answer every question an officer asks. The questions remain voluntary. So do the answers. So when the travel questions start, you have one phrase that ends the trip without a fight. Officer, I prefer not to answer questions. Am I free to go? Say it once, say it warm, then stop. That phrase does something most people miss. It's 2 moves in 1 sentence. It protects you from one of the classic report writing bricks, inconsistent statements, and it forces him to declare his hand. Either he lets you go, which means he knows he doesn't have enough, or he says you're being detained, which means he now has to articulate a reason on the spot. Either way, the clock has started running differently. It is running against him, not you. The key. Mind if I take a look? Now we get to the move that ruins honest lives. And I mean honest, not guilty. There is a specific moment in the script where the officer leans a half-inch closer, lowers his voice a touch, and says something like, "You don't have anything in the car I should know about, do you?" Or, "Mind if I take a quick look?" Or, "You wouldn't mind if I just check real quick?" It sounds friendly. It sounds helpful. It sounds like the kind of question a nice person has zero reason to refuse. And that is precisely why it works. Under the Fourth Amendment, an officer does not have free access to your car. He generally needs one of 3 things to search it. A warrant. Almost never happens on the roadside. Probable cause. A specific, articulable reason to believe evidence of a crime is inside. Or your consent. And consent is the magic key. The moment you say, "Sure, go ahead," every protection the Fourth Amendment put between you and his flashlight dissolves. He can go through the glove box, the center console, the trunk, your bags, under the seats. Anything he finds is admissible in court because you said yes. 2 Supreme Court cases sharpen this further than any other line in the script. First, Schneckloth versus Bustamante, 412 U.S. 218, 1973. The court ruled that consent to search is valid even when the person consenting doesn't actually know they can refuse. The officer is not required to inform you of your right to say no. He can stand there, ask for permission, and watch you say yes, and he is under no obligation to mention that you had a choice. Second, Ohio v. Robinette, 519, U.S. 33, 1996. The court ruled that even after the traffic portion of the stop is finished, even after he has handed your documents back, he does not have to tell you that you're free to go before he asks for consent. He cannot make the request feel like an order, but he can make it feel like there is no moment at which a refusal would be welcome. So here is the sentence that you have to memorize, like your own address. Calm, polite, no justification, no apology. No, because I know my rights. Officer, I do not consent to any searches. You're not resisting. You're not obstructing. You're lawfully declining to volunteer away a constitutional right. You don't have to explain it. You don't have to defend it. You just say it and you stop talking. What if he pushes back? Because he will. He might say, "If you've got nothing to hide, you wouldn't mind." You reply, warm and unbothered, "I understand, officer, but I still do not consent to any searches." Same line every time. He might say he'll bring a dog out. You stay where you are. You are not resisting. You are declining. Saying no is not an admission of guilt. It is the single most lawful move an innocent person can make. The Constitution stands squarely behind you when you say it. The plain view window. Roll it all the way down. Now the script shifts from your mouth to your car. 2 things happen at once. The officer tells you to keep your hands where he can see them. That's lawful. You do it. Hands on the wheel. Announce every reach before you make it. My license is in my wallet. I'm going to reach for it slowly now. No surprises for him. No surprises for you. Then he says, "Roll that window all the way down. Don't steamroll the order. Don't roll it down 3 inches and brace your arm. He does have the authority to ask, and you create more problems than you solve by refusing small lawful instructions. But understand why he wants it. 2 reasons. First, plain view. The moment he can see clearly into your passenger seat, your center console, the floorboard, anything sitting out in the open is fair game. No warrant required. No consent required. He can act on it instantly. Second, smell. Historically, in many jurisdictions, the smell of certain substances coming through an open window has been treated as probable cause to search the whole vehicle. That doctrine is shifting fast. In states that have legalized marijuana, courts are increasingly ruling that odor alone is no longer enough to justify a search the way it once was. In other states, it still can be. The rule depends heavily on where you live, but the principle holds everywhere I have ever seen. What he can lawfully see and smell, he can lawfully act on. So the practical move is straightforward. Before the stop ever begins, your private items stay private. Don't toss your gym bag on the passenger seat. Don't leave a prescription bottle sitting on the console with the label facing out. Don't open a cold beer in the cup holder. What you put on display is what he can use. Pull over tidy. Don't give the window a thing to see. If he tries to use what he saw as a justification to search, your line doesn't change. Officer, I do not consent to any searches. Same 6 words, every time. Stepping out. Step out of the car. This is the one where a lot of drivers freeze. Can he really make me get out? Yes, he can. And the law is not in dispute. 2 cases settle it. Pennsylvania versus Mims, 434 U.S. 106, 1977. The Supreme Court ruled that during a lawful traffic stop, an officer may order the driver out of the vehicle. No special reason required, just the stop itself. Then, 20 years later, Maryland versus Wilson, 519 U.S. 408, 1997. The court extended the same power to your passengers. The officer can ask everyone out, simply because the stop happened. So when he says, step out, you step out, calmly, hands visible, slowly. You don't argue this one on the tarmac. This is not your hill. But understand what stepping out is actually for. It separates you from the car. It separates you from the passenger, so he can question each of you alone and compare the stories. It puts you on the pavement, where he can watch your eyes, your balance, your hands, anything that becomes signs of impairment in his report. And very often, it's the opening move toward a pat-down. Here's the part most people miss. Obeying a lawful order to exit the vehicle is not the same as consenting to anything. Getting out is not consent to a search. Getting out is not consent to answer questions. So the moment he moves toward a frisk or starts the casual travel questions all over again, your mouth is still in the game. I do not consent to any searches, officer. For the questions, I'd prefer not to answer questions. Am I free to go? If he moves to pat you down, you should know one more thing. Terry v. Ohio, 392U. S1, 1968. An officer can frisk the outside of your clothing for weapons, but only if he has a reasonable, articulable reason to believe you are armed and dangerous, not just a hunch, a specific reason he has to put on paper and defend in court. Don't physically resist the pat-down. You can say it clearly and out loud. I do not consent to this search. Let the record show it. Your fight is the courtroom, not the asphalt. The wait. Just sit tight. I'll be right back. This is the last move in the script, and it might be the most important because it is the one you can't see. He hands back nothing, takes your license, says, wait. You wait. 5 minutes? 10? 15? You're watching the rear view. You're wondering what's taking so long. Here's what's taking so long. He is stalling. He is running every background check he has. He is calling for a second unit. And in many departments, he is waiting for a K-9 officer to walk a dog around your car. He is burning the clock on purpose, hoping something turns up if he just buys more minutes. The case that protects you from this is Rodriguez v. United States, 575 U.S., 348, 2015. The Supreme Court ruled that an officer cannot extend a traffic stop beyond the time reasonably required to handle the reason he pulled you over, not without a separate, reasonable, articulable suspicion of some other crime. The stop has a mission. When the mission is done, the stop is done. He cannot hold you on the side of the road indefinitely, fishing for a dog, hoping to get lucky. So how do you actually use that ruling? You don't recite it on the roadside. You'll lose that argument every time. What you do is much simpler. At the natural moment, after he's run your documents, after he's come back from the cruiser, after the wait has stretched, you ask 4 words. Calm, respectful, eye contact. Officer, am I free to go? That single question does something crucial. It puts it on the record. Either he says yes and you leave, or he says you're being detained, in which case the clock is now running against him, and he has to come up with the separate reasonable suspicion the Supreme Court said he needs. Ask it once. Ask it politely. Then wait it out in silence. The final layer, the right to remain silent, is spoken out loud. Now I owe you one warning, because the entire strategy only works if you do it the right way. The temptation is to just stop talking the moment the lights come on. Total silence. Stone wall. The problem is that the Supreme Court has ruled that simply going quiet is not the same as invoking your right to remain silent. And the case that proves it is Salinas versus Texas, 570 U.S. 178, 2013. I want to be precise about Salinas because it's important and a lot of people get it wrong. That case involved a man who voluntarily went to a police station for questioning about a murder. He wasn't in custody. He wasn't read his Miranda rights. When officers asked him a difficult question, he went quiet. The court allowed that silence to be used against him at trial. Not because silence can never be protected, but because he never clearly said he was invoking his right to remain silent. He just stopped talking. That wasn't enough. So the lesson that ties this whole strategy together is this. To use your right to remain silent, you usually have to speak up and claim it. You don't just clam up and hope the officer notices. You say it plainly in a sentence. You should already be memorizing right now. Officer, I'm going to remain silent, and I do not consent to any searches. Then you stop talking. That single sentence is your shield. And the shield only works if you actually raise it. The whole game in one breath. Let me run the entire script against the wall one more time. So you drive away with the whole thing. When the opener comes, kind, brief, redirect. Doing okay, officer. How can I help you tonight? When the trap comes, do not confess. No, officer. Why did you pull me over? When the fishing trip starts, shut it down, force his hand. I'd prefer not to answer questions. Am I free to go? When the key is offered, never ever say yes. Officer, I do not consent to any searches. When the window goes down and the hands come up, comply, physically. Save your mouth for the search request. Same 6 words every time. When he tells you to step out, do it. Slowly. Hands visible, then keep your mouth where it was. When the clock drags and the cruiser door keeps opening and closing, Officer, am I free to go? Then wait. And the master line that ties every move together. Officer, I'm going to remain silent and I do not consent to any searches. Comply with your hands, decline with your mouth, win in court. That's the whole game. The script on the road is written for the driver who doesn't know the rules. The driver who wants to be helpful. The honest driver. There are millions of them on the road tonight. The officer is counting on them being one of you. Don't be a count. If this put even one line into your head that you didn't already have, do me 2 favors. Tap subscribe so the next honest driver finds this before they need it, not after. And stay close. In the next video, I'm walking through the 4-word phrase police use that sounds like common courtesy, but is actually another trap. We just want to talk. That one trips up more decent people than almost anything on the roadside. I'll show you the line that ends it cold. Until then, keep your hands where he can see them, keep your mouth where the Constitution can hear it, and know the lines before the lights come on.